Okay, so good morning. Welcome to this month's webinar. We're already into autumn, it's hard to believe, but I think this is a subject that clearly, by the numbers that have registered for today's webinar, is of great interest, and I think it relates to every organisation, regardless of the sector that you might work in. Where, as it says on the screen, as you know, we're going to be talking about subject access requests today, in relation to best practice and ensuring that you meet your legal requirements as an organization. Before I introduce today's guest panelist, I'll just quickly run through the schedule. We're going to be focusing on the current landscape, and that relates to the kind of data and statistics that we're seeing in relation to subject access requests at the moment, and how that's sort of manifested over previous years and what we might continue to see. We'll focus on the right of access, which relates specifically to UK GDPR and the rights, and we'll talk about them in great detail. We'll focus on subject access requests in terms of the actual process, how to manage them effectively, and best practice, along with some case studies, some recent case studies to give you an example of the kinds of things that can go wrong in relation to subject access requests and how the ICO views and responds to them. And we'll talk a little bit about our service offering, which may be of value to you if you're not already a client of more ClearComms, in relation to how that might, apart from all of the other areas that we focus on in relation to data protection and privacy, it does include support and guidance in relation to subject access requests. And I'm joined again by our wonderful panelist, Megan Mirza, who's a Senior Data Protection Officer with More ClearComm. Megan, good morning. Are you all right to just give us a few moments about yourself and your background, and what you hope
Yeah,
to
good
get from
morning.
today?
And yep, sure. And thanks for coming along, everyone. This is a really interesting subject to sort of focus on for today's session. My background was actually working for the regulator, the Information Commissioner's Office, and I was there for over 10 years. So I have quite a lot of experience of dealing with this particular aspect of the legislation. And I now work with clients, so provide advice on subject access requests that clients might receive. It is a complicated area in terms of you need to have processes in place to manage those requests when they come in. And that's something we're going to touch on today. But as I said, thanks for coming, everyone. Hopefully, you'll go away with some ideas in terms of how this might work in your organizations, or just being prepared, even if you don't get many requests, that you might get a substantial one that takes up a lot of time and resource. So that's something we're going to touch on today as well. So welcome, and hopefully you enjoy the webinar today.
Thanks, Megan. And I think similar sessions or on along these themes that Megan and I have run as co-hosts, we've had probably the highest attendance rates of the webinars that More ClearCom runs, which is interesting. And also we tend to get an enormous amount of questions. So we will, if it's appropriate and the timing is right within the webinar, we may respond to some of your questions as they appear in the Q&A. However, you can also email both of us direct if you've got any specific questions. Everyone will be benefiting from the slide deck, and today's session is being recorded. So this will also be available on the More Kingston Smith YouTube channel and via the MKS website as well. So the key thing I think I need to just emphasize before we get going is it's impossible in an hour's webinar to provide a full and in-depth training session on DSARs, Megan, I think, isn't it? So this is
Yep.
more about awareness, focusing on those key points that are on the screen there in the schedule. And from that, maybe answering your questions on a one-to-one basis, because I think it may be specific to your organization. Is that fair to say, Megan?
Absolutely. And there's also an option for us to come out and do a training session if you do
Yeah,
want that more detailed sort of explanation of the legislation. So this is really a very much an overview for you
yeah.
to go away and be thinking about how it might work in practice.
Yeah, great stuff. And I think we're also conscious that of the people on today's webinar, there will be some that have experienced subject access requests in maybe a good or a bad way, and others that have never received one, and maybe hopefully today will help you to get a better idea of what to expect. So in terms of the current landscape, I think we probably have to go back to 2018, the early part of that year when people were experiencing, maybe for the first time, the media focusing on data protection and privacy legislation with the GDPR coming into effect. And then followed 2 years later, we had Brexit and the introduction of the UK GDPR, which I think I'm right in saying, Megan, replaced the previous version, but doesn't change too much.
Yes, there's some minor differences, but we will see the UK moving further away from GDPR, and there's some legislation that just came into play yesterday.
Yeah.
But it is broadly similar in terms of the requirements and the provisions.
Got you. Yeah, yeah. We'll briefly mention that right towards the end, and the impact. And I think, and this is from personal experience, Megan's experience, and all of our colleagues in our profession, and just generally anyone who was in business in early 2018 probably experienced a rush to become GDPR compliant in inverted commas. I definitely saw a proliferation of myths and misunderstandings, stress and fear. An obsessive focus on consent was one of those, I think, Megan, wasn't it? Everyone just, that was something that people latched onto,
Yeah.
as one of the sort of issues to be worrying about, and definitely a focus on creating documentation and evidence rather than behavior and change. And I think that's something, when we talk about data privacy cultures and actually living and breathing this stuff on a day-to-day basis, that was probably one of the sort of mistakes that most organizations made, back in that time. But I think, and I'll ask Megan for her thoughts on this, a standout fear that I saw was this immediate and ongoing deluge of subject access requests. I think people thought this was just going to hit them immediately and become a massive issue for them to deal with logistically, the costs, etc. So is that something that, especially with your background, that you saw happening?
Absolutely. So I was at the ICO at the time that the new legislation came into play. Some of you, or most of you, will know under the previous legislation, there used to be a fee for individuals who wanted to make a subject access request. So it was a £10 fee or £50 if it was in relation to medical records. And that was seen as preventing people from doing sort of scattergun requests because you had to pay that £10 fee. So the fee went with the introduction of the new legislation. So requests were free. And there was real concern from most organizations that they were just going to be inundated with subject access requests because they were free. Um, so there was definitely a peak,
Mm.
but it then plateaued out. And I think it's probably stayed on that rough plateau over the last few years. But it does, because it is free, it does make it easier for people to make requests. So again, this is why this session is important in terms of raising awareness on how to deal with those requests when you do receive them.
Yeah, because they're now a, what I would refer to as a fixed cost, and something that every business can and should expect to happen, and they need to be able to manage them, I guess. So
Yeah.
in terms of the current landscape, so what we're seeing in the moment from the Information Commissioner's Office is that they say that generally about half of all of the complaints made to them relate to subject access requests and the difficulties that people have when trying to access their personal information. Um, Research suggests that almost three quarters of subject access requests incur costs to the business of about £3,000 in terms of managing that activity, although 7% actually cost over 10,000. And I guess that would relate to the complexity, Megan, and the volumes of data, I guess, and the nature
Yeah.
of it.
Yeah.
Yeah.
Absolutely.
And in that period, from April to 2022 to March 2023, in that 12 months, nearly 16,000 complaints were made to the ICO relating to subject access requests. So that's from individual members of the public who have complained to the ICO that their request has been managed in a dissatisfactory way from their perspective.
And it's mainly
Yeah,
that they haven't been dealt with within the timescales, and we'll talk about
right.
the timescales, or they've had a response, but they believe that the organization holds more than what's being provided to them. So
Okay.
that's the sort of general gist of the complaints that people have.
Yeah. It's I mean, the numbers on screen, just to be for half of, when you consider all of the rights, as we're going to mention in a moment, under the UK GDPR, for half of them to be about just one of those rights is really interesting to me. Um, we've seen multiple public and private sector organisations being issued reprimands by the ICO, in some instances monetary penalties, again for failing to respond to them within the timescale, as Megan mentioned. It's not so easy to identify private sector performance data on subject access requests, but they're likely to be equally poor or maybe even worse. And I think the reason that they're not maybe so publicly available is because it's, again, it's volume, whereas maybe the public sector organizations, experience vast numbers um, of DSARs, and would they be, from an operational perspective, Megan, would they be set up to manage them on a larger scale?
So in terms of public sector, and I've been out to some of the big government departments, and they are literally like it's like a factory shop floor in terms of
Yeah.
processing requests, and they can be getting up to 300 requests a month. Um,
Wow.
Smaller organizations that may not get anywhere near that, likewise do have similar processes in place, but that's hopefully the key message from today. It is important to have a process, whether you get one a year or whether you get 10 a month. You need to have a process in place, because that time scale, which we'll talk about, quickly goes, and that's where you risk complaint to the ICO.
Yeah. I guess it goes with this sort of common theme in other areas of all business, that the less, and life really, the less you do something, the more difficult it can be. And I guess, although they're not great to receive, the more you do, the better you kind of get at managing them over time, and you evolve that process, I guess. Interesting view from the Information Commissioner's Office in relation to how employers are consistently misunderstanding the nature of the requests, or definitely underestimate the importance of responding to them. But the interesting bit that I take away from this is the final part of that second paragraph, which definitely for me suggests that they are committed to continuing this focus on taking action where necessary, when DSARs are not met within the legal requirements. So this, I think, really underpins the importance and relevance of today's session, and why hopefully either you'll take something away from it which will help you immediately, or will maybe generate some questions that you can then pose to us specifically. So the ICO also carried out a public attitude survey this year. Interestingly, over half of the people surveyed hadn't heard of the term information or data rights, which is very interesting.
It
And
is interesting because
sorry, yeah,
they're not terms that you would normally use,
no,
but the broader sort of message there is that not everyone is aware that they have rights under the data protection legislation.
yeah. So did they
So
maybe
that's
avoid?
important.
Yeah, did they maybe avoid legislative terminology there and actually go for the question of, do you realise you have
Possibly.
rights in
Yeah.
relation to your data, perhaps?
Yeah, possibly.
Yeah, but what's on screen now, I'll invite Megan to sort of comment on this, because it definitely relates to the rights within the GDPR itself, doesn't it? I think, in terms of awareness of people's rights. And again, I think in the next couple of slides, we'll focus on the rights themselves.
Yeah, and I think it's just important to note the ICO do this public attitude survey every year, but it is interesting to note that the percentage of people that are aware of their rights has gone up slightly, but not that much, given that there was a very big media fanfare at the time the new legislation came into play.
Mm,
It's relevant for you as an organization, because the more people become aware of their rights, the more likely it is that you're going to get a request of some sort, whether it's a subject access request or one of the other requests. So people are generally aware, but in terms of marketing, they don't necessarily correlate that to being linked to data protection. And
okay.
they see it as unsubscribing
Yeah.
to receiving marketing, but not necessarily connect that with the data protection right of opting out. So yeah, it's quite interesting, but it's broadly plateaued in terms of the public awareness, I would say.
Yeah. Interestingly, I guess, is to look at this in the right context, I suppose, in terms of where we are now. It would be easy to look at some of these numbers on screen, and there's a couple of more I'll share in a second, and think that they look relatively low. But I guess if we were to go back 6 or 7 years, they would be infinitely lower than this again.
Yeah,
So I think that it is fair to say that because of the legislation and the focus in the last 6 or 7 years, there is a generally greater awareness that our data has value, and we should value it, and it should be respected, but still not where it needs to be in terms of the numbers we're seeing. And the bottom two bullets we've put into bold because they relate, I think, specifically to what we're talking about today in terms of subject access. Um, so again, um, only 20% of the public have asked an organization to provide copies. So that is, am I right in saying that talks specifically about subject access requests, Megan,
yeah,
doesn't it?
yes.
So only 1 in 5 people has actually at any time submitted a subject access request. Slightly higher number are aware they have the right to find out and to ask for copies of it. So that's interesting. I think that's very low, to be honest. I think that um, for less than 4 in 10 people to be aware they even have the right to find out and ask for that stuff, I think is. But does that
Yeah.
surprise you, or is that kind of where you think it realistically sits?
For me, that doesn't surprise me.
Mm.
Sort of, if you speak to people in a sort of social setting, they'll generally not be aware of data protection rights,
Yeah.
on a general level. So no, that figure doesn't surprise me.
No, I know that we work with multiple clients and we support clients from all sectors, but I think when you're in a certain profession, it is very easy to lose sight because you're talking about this stuff every day, that it isn't actually common language and terminology for the general public. And so yeah, maybe we shouldn't be surprised. So let's focus on the right of access. I'm going to hand over to Megan for this one because I think this is really important and it's definitely legislation focused, but it sort of steers us into hopefully raising awareness also of everyone on today's session. These rights relate to you, don't they?
Yeah, absolutely. So it's, for you as an organization in terms of responding to requests, but equally for you in your out of work lives, you have these rights in terms of the organizations you might be interacting with. So there are a number of rights. I'm not going to go into the depths of the other ones, but just to say that the right of access sort of sits at the pinnacle of rights in terms of what is considered to be a fundamental right. So the other rights sort of stem off that. So in order to, for example, request erasure or request deletion, you need to know what an organization is processing about you. So the right of access is normally that first look into what an organization is doing with your personal data. And then the other rights, as I said, sort of lynch or hinge on that information that you might get. So you might make a request to an organization, you'll get some information back, which is your personal data. And you might then notice that there's inaccuracies in that data. So then you might put in a request to rectify incorrect information. Or, as I said, you might ask them to delete the information if they no longer need to be processing it. So it is a key and fundamental right. It is really important that organizations get it right because people will complain to the ICO, as we've seen, and it doesn't take much to prompt the ICO to start looking a bit closer at organizations if they are getting many complaints about an organization's inability to deal with requests appropriately and in line with the legislation. And once the ICO starts lifting that lid on an organization, that is where things can quickly start to unravel in terms of, whether you've got the right framework in place, whether you've got policies, procedures, etc. And they could potentially come in and do an audit on the back of that if they had real significant concerns. But the main thing for you is around your reputation. You want people to trust what you're doing with their data, and you have to be transparent with people about that as well. So, getting it right in terms of dealing with the requests is really important from a reputational perspective, but also linked to that is the potential enforcement action that might arise on the back of it if you don't get it right. It is a tricky area, but it is really important that you do get that right. So we will talk about that in a bit more detail. But just to say, it is a key fundamental right. And when people complain, the ICO do look at those complaints.
Yeah, and a couple of interesting thoughts there as you're speaking, Megan. So in terms of basing, what we know about the fact that the right of access is that kind of hinge from which everything else swings inward, if you like, and then factoring in that um, we're still on those relatively low percentages in terms of people understanding they have these rights at all. I guess it stands to reason that as that number increases over time, all of these things are going to become more of a regular pressure and a logistical headache for organizations to manage, especially because I think when we talk about right of access, we think about a subject access request and just providing copies, but probably most individuals and most organizations probably don't understand that all of these other rights can then become an issue for them to manage and probably don't have processes and procedures in place to manage it, I guess.
Yeah, and it's it's recognizing that request when it first comes in. Actually, what does
Mm,
that mean? If someone wants you to delete their data, what does that actually mean? Do we have to delete everything that we hold about that particular individual? What
yeah,
happens if it's an employee making that request? And they're, in my experience, the most challenging ones to deal with, particularly if it's in the sphere of a disciplinary or a complaint or something along those lines, an investigation going on in the background. That's where this gets particularly difficult for organizations to deal with.
yeah. It's a lot easier for someone to submit a subject access request than it is for the organization to manage it, is a fair statement, I guess.
Yes, it's fair.
Yeah. Okay, so we're going to talk about the right of access in particular today, as Megan said. Um, and again, I'll hand back to Megan just to talk us through um, what it actually is, and that'd be good, because I think, as Megan said, you can imagine how long it would take us to go through all of the rights. But as we're talking about this particular right today, I think this bit of focus is really important.
Yeah, so
Oh, sorry,
we're
Megan.
not going to the depths, as Rich said, of the legislation, but really just to bring it to life. So, as you saw, it is one of the rights that people have, individuals have, and essentially it gives people a right to request a copy of any personal data that the organization is processing about them. And so, as I said, that could come in from one of your clients, it could come in from a customer, a member of the public, it could come in from an employee, could come in from one of your partner organizations, it could come in from any angle. And you have a time frame in terms of responding to that request, and there may well be exemptions that you need to apply. So it's not a case of, right, we have to give them everything that we are processing, but there is a lot of consideration that needs to go into whether other people's personal data might be tied into that information that we might need to redact, whether any exemptions apply, as I said. How are we going to produce this information, because you don't need to send the documents, but you may need to cut and paste the information into a separate Word document, for example. How are we going to send it to them securely? And just going back a step, how do we know the person is who they say they are? So we need to do some ID checks there, possibly. So this all takes time, and you're working up against a really tight time frame in terms of responding to that. But essentially, people have a right to request a copy of any personal data that the organization is processing about them. That's the fundamental position. And then everything falls off that in terms of whether exemptions apply and stuff like that.
Yeah, I mean, it's worth pausing actually at the moment, because I know the one thing that, especially in the early days when I was working in this field, was that question that was regularly asked: Am I a controller? Am I a processor? Um, what is a data controller? And obviously, we mentioned data controllers here a couple of times on screen. So, would it be okay for you to just give us a brief overview of what a data controller is and maybe how that differs to a processor?
Yeah, so just quickly on this. So I keep referring to organizations. The organization who determines the means, the manner, the purpose. So who is the organization making decisions over the data, deciding why you are processing, how you are processing someone's information, on what systems, what retention periods are in place, all that decision making around the data will make you, the organization, a controller under the data protection legislation. A processor is a separate organization who you have instructed to process personal data on your behalf, but you are ultimately responsible for what happens with that processor. So I won't go into the depths with the processor controller relationship, but just to
No.
say that the controller is the organization that is making the decisions on the data, the personal data that it's processing.
Yeah. And if a controller instructs a processor to act on its behalf, it still retains that responsibility under the
Yes.
legislation. Yeah.
Yeah.
Okay. I think we might have, just going to check, we may have a couple of questions. Um, I'll just quickly see if they're, um, oh yeah. So one of the questions was what counts as processing. So I think we've just answered that one.
So just to on
Yeah.
that point of what is processing. So processing, just remove processor out of the picture for the moment. Processing is anything you do with the personal data in your organization. So it's the whole life cycle of the data from the point that you collect it. You know, you may print it, you may hold it on your systems, and then right to the point when you delete that information. So you'll be processing daily on a day-to-day basis, and that's
Mm,
processing is anything you do with that personal data.
yeah. Yeah, got you. So the questions are popping in thick, thick and fast
Oh,
as I
they
go. So I'm going to try and manage it as I go. Yeah, some of them are very specific. So they will be questions I think that we will probably best answer in the time we've got after the event.
okay.
Um, so one question, for instance, does supplementary information cover the supply of copy emails as they've requested, which would have been exchanged prior to leaving employment with us? So these are it's interesting because these are very specific questions, and this is what I think we alluded to at the beginning, that there will be case by case examples. Is that something you can answer now, or rather do after?
Yeah, I mean, quickly on that point on the
Yeah,
slide, we refer to supplementary information. When you respond to a subject access request and you provide the individual with what they're entitled to receive, there is also a requirement to give them some other information, such as who you share their personal data with or where you obtained it,
yeah,
and some other sort of detailed information, similar to what you would have in your outward facing privacy policy or privacy notice.
yeah,
In terms of requests for emails, etc., it is entirely up to you as an organization how you provide the information back to an individual if you are going to give them the information, or you can just take out the information that is their personal data. So it may be the content of an email, rather than the whole email itself, or you may redact some out. So each of it's very much case by case, the approach in terms of who the individual is and what exemptions might apply.
okay. Brilliant. Thanks, Megan. And like I said, every question we get posed today, we will respond to
Yeah,
um, individually. So yeah, if we can just sort of briefly go through these again, very much on the theme we're talking about.
yeah. So
Yeah.
I mean, I was just going to say an individual is only entitled to their own personal data, but that sounds quite easy on the lid of the tin. But
Mm,
actually, most information is going to be intertwined with information or names of other individuals. That type of thing. You might have documents, a report, for example, that may mention other people. You might have meeting notes. You might have email chains that reference other people. They are, as I said, they're only entitled to their own personal data. So there's options around where other people are mentioned. So you can either redact or you can get permission to share that information. But that's where you'll often see lots of redactions happening where there's references to other people within the information. Yeah, there's a lot of work that goes into this in terms of those redactions, and particularly when
yeah.
there's other people involved.
Yeah, absolutely. Yeah. And the bottom graphic, I think we've created it in a different way because this is a question that we get asked equally by clients and also by I get asked this by friends and family. You know, how do we hear about our right to submit a subject access request, but how do we actually do it? And it isn't stipulated, is it? So it really is. There's lots of so I can't speak variable ways that a
There is,
subject
and
access
and
request can
again,
be submitted.
organisation absolutely, and organisations need to be alert to this. So someone could literally ring you up and ask for you to provide a copy
Okay.
of their personal data. So it can be verbally, it could come through social media, or it could come through by email, just to one of your generic email addresses. And we have a case study that touches on that.
Mm,
So yes, organisations need to be alert to different ways in terms of how people can reach you and make requests, and they're
yeah.
all valid requests. So you need to then deal with them as they come in.
Sure. Just as an aside, would you recommend a telephone method? Because I guess there would be not necessarily evidence that you submitted it.
So with yes, individuals can make those requests
Mm,
verbally. So they could literally ring you up and ask for you to send a copy of their personal data. You would then need to follow that up with a written process. So because you
right.
would need to check ID, and
Yeah.
so you might need to ask them to clarify their request as well. So that it's inevitably followed by a written process, but the initial request could come in over the phone.
Got you. Okay. Thanks, Megan. So we'll talk a bit about the actual process itself. This is a common question in terms of what's the actual process. How do we manage it. We support our clients with subject access requests in a variety of ways. It can be more hands-on. Some are quite happy to handle them themselves because it may be more routine and it's just about us offering the support in hand. But in terms of the actual process, Megan's just going to take us through what a typical DSAR process looks like. Again, you'll have these slides provided to you, and the recording will be made available fairly soon after today's event. But I think this is a good run through, just to give you an idea of what might happen.
Equally, we've kept it really high level as well.
Yes, we've
And
definitely avoided detail because there's so much that there's so many depths we
yeah,
could have gone to. Yeah,
and as I keep saying, and that case by case is terminology that you'll see all the time. It is very much down to looking at the individual cases in terms of applying exemptions and all the rest of it. But this is general level, sort of high level things that organizations definitely should be considering.
yeah,
I would always say there should be someone within the organization who is allocated responsibility for data protection. I mean, and there is a lot of requirements that hinge off this as well, but particularly in relation to requests. So there should be a single point of contact within an organization where requests should go when they are received by the organization. So the receptionist sitting on the front desk in your office should know what to do if someone comes in and makes a request for their personal data. Likewise, if someone rings a helpline, for example, they should know what to do with that request. So that's really important that you have someone that knows what to do when that request comes in. Then you need to think about who's actually making the request. Is it a member of staff, for example? Is it an employee? Have they made the request via their work email address, for example? Then you may not necessarily need to do ID checks because you'll have knowledge of who that is and that it's a valid communication email in terms of knowing who that is. But you may, if it's coming in from a member of the public for some really sensitive information, for example, you would definitely be having to check ID and go through that process. It's all about making sure those checks are proportionate. So if you're going to be potentially disclosing some really sensitive information, such as health information or something to do with childcare or something along those lines, you would be checking ID to make sure you are disclosing it to the right person. But if it's an employee who you know, then you wouldn't necessarily be requiring them to provide you with copies of their passport or whatever to verify who they are. So there's that element to it because the risk is that if you provide information to the wrong person, that's a breach of the data protection legislation. So that's a risk if you don't do those checks appropriately. And then you need to check what it is they're actually asking for. And you can seek clarity if it's not clear or you hold a lot of information about that individual. You can go back and ask them to clarify or be a bit more specific if that might help. They're not obliged to make it specific, but you do have, there's a requirement or provision in the legislation that allows you to do that. And the clock doesn't start ticking until you get that information back, and then the clock does start ticking. So there's this reminder you need to make sure, because you have a month to turn that request around. So you need to make sure that you do that within that time frame. Otherwise, you are potentially breaching the legislation. There is an additional 2-month extension that in some cases you can rely on. That is only in the most complex of cases. And there needs to be a justification for that extension. And you also need to let the person know, the requester know, that you are extending the time and why. And then check what they have requested, double check, but equally check and double check before you release any information as well, in terms of making sure the exemptions applied correctly, redactions have been done appropriately, and that you are not risking disclosing information that you shouldn't send to that individual. That's a big risk. And that where we get into potential breach territory. And we've seen fines for organizations that haven't properly redacted material properly and released it.
yeah. I mean, before we move to the next slide, it really does sort of emphasize to me the importance of an organization having this as a step process,
Yeah,
almost to sort of systemically work through this when a DSAR comes in to make sure that each of these stages have been managed properly, I think.
yeah. On that note.
Yeah,
So searching, and
neatly done.
so searching for the relevant information. So that can be tricky. Time consuming. You might need to be quite sensitive about who you're asking for information, particularly if it's in the context of employment, or an employee making that request. But the searching itself can take some time, particularly if you've been dealing with someone for 20 years and you've got 20 years worth of personal data, for example, an employee, a long-term employee. As I've touched on the redaction, looking at if there's other people mentioned in the information, preparing the response, and then doing that and sending it out securely as well.
Yeah,
So there's a lot of steps that you need to build into the process. And you may only ever get one request, but it might be a really complicated request and it might be very contentious. There might be some sort of disciplinary going on in the background, and that can
yeah.
take up a lot of time and resource.
Yeah, as an organization, we support our clients, a lot of our clients, with business continuity planning and and ensuring that what they have in place for when the worst happens, whether it's data protection related or cybersecurity, is that they can manage it effectively. And we talk about consistently about business continuity planning in relation to testing a plan, and that if you've got a plan that isn't tested, then you can assume it probably isn't going to work in the way you hope. Does that go into step six there in terms of searching for the relevant information? Am I right to assume that most organizations would have no idea about how long it might take to actually find all the information that's required until it's actually asked for, and that's why many get caught out, especially on the first one they receive? Is it something they could almost sort of dummy run and just sort of get a better idea before they actually get hit with a real one?
And yes, absolutely. And that's often the queries I'll be dealing with is we have so much information, we don't know where to start looking, particularly when it's digital and that it's in emails. And, do you access people's inboxes to get access to information? Um, it gets really challenging. And then if you've got archives, because that's still held. So you may need to go into your archives, and search for information in there. It is time consuming, but it's also making sure you have that mapped out in terms of who are the key people across an organization who we need to contact if we do get a subject access request,
Got you.
and in terms of mapping out where the data might be. And that links back into having records of processing activities, which is a mandatory requirement. And that will indicate where your personal data is across the organization, which is why that data inventory is really important. It does save time.
Got you. Yeah. So I'm going to ask you a couple of quick questions. I'm conscious of time, but I think these can be possibly answered relatively quickly. What about parents requesting data about their children? What are the rules and regulations in that area?
That's a really difficult area, because children do have rights themselves, and often it's down to the capacity of the child, the age of the child. Um, but we've seen cases, you'll probably remember a few years ago, a mother was trying to get hold of GP records for her daughter who was 16, and that was refused.
Okay.
Yeah, it is a difficult area. I'll go back to the same point. Each request needs to be assessed on a case by case basis.
Yeah.
There could be fractured family background where, father is making a request where he may not be
Mm.
entitled to get those records. So each needs to be assessed on its merits. But children do have a right to make their own requests. But then the organisation needs to look at that in the context of whether they have capacity, how old they are,
Yeah.
what's the relationship with the parents and the organization, that type of thing.
Yeah. Assuming this question comes from someone, I don't know, comes from someone who perhaps works in a field of work that does involve children, such as schools or in care, a care background, for instance. Um, it would be fair to say, I think, Megan, wouldn't it? But organizations in that field would need to focus perhaps more than most on being aware of the rights and maybe seek third party support from such as someone such as more
Absolutely, yeah.
ClearComm
And
as a
I mean,
routine, really.
absolutely. And what's always been in my mind, and the legislation does cover this with certain records, such as health records and education records, actually, for that matter, is the harm or damage that could arise if those records were disclosed.
Yeah.
And that's something that should be in the forefront of your mind when you are looking at it, particularly if it's health, education, or social care, is what harm or damage might arise. And that then leads you down the route of potentially applying exemptions in that case as well.
Yeah, absolutely. So what I'm going to say at this point is that if we seeing how we do for time, we'll answer more questions as we get to the end. Time frames has popped up in a couple of the questions, and I know that when we were creating these slides, originally we had a bit more content on screen, and we dialed that back a bit, didn't we? And it would be easier to just focus on the two pivot points we've got here, and then kind of talk from there, I think.
Yeah, so I have touched on this. So you have a month from the day you receive the request to respond. That's the legislation
Yeah,
that sets out that time frame. The uh, as I said, it can be extended by 2 months if it is complex, but that bar of complexity is high. So it would be cases where you've got 20 years of data, for example, to go through, or you might need to seek legal advice, that type of thing. So
yeah.
they are unusual cases that, I mean, but the provision is there. If it is complicated, complex, etc., then you are entitled to extend that by 2 months.
Yeah, and when
So
we
as
say
a yeah,
months,
go on.
it's sorry, yeah, when we say months, it's not defined specifically, is it, in the
It's
legislation or?
it's a calendar month.
Got you. Yeah,
So if you received a request today, 24th of October, you would have to respond by the 24th of November.
got you. So it doesn't
Yeah.
factor in working days or anything like, or the
No,
specific working patterns of an organization.
no, it
Got you.
doesn't.
Yeah, that's when it
Which is
starts.
not, yeah, not helpful, but anyway. But the ICO says
Yeah,
if you are looking to automate some of this process, you would look at a 28-day turnaround to make sure that you absolutely do comply with the law. So
got you.
that's their guidance. But yes, you have a month.
Yeah. On the
Um,
second point, we actually did have a
yeah.
question about this, and this is the reason I didn't answer it at the time because I knew this was coming. So yeah, that would be great if you could talk about proof of ID.
Yeah, so there are 2 points. So I saw mention you can seek clarity.
Hmm.
So if someone's just making a bit of a scattergun request, I want everything you hold. You could go back and seek some clarification on that. The clock wouldn't start ticking until you get that clarification back.
Yeah.
And the second is proof of ID. The clock again won't start ticking until you've satisfied yourselves that the person is who they say they are. But you need to be reasonable with that. I've seen cases where organisations were requiring people to get statutory declarations to say who they were, and that
Mm,
was said to be completely over the top or disproportionate. But you need to think about what you as an organisation are satisfied with. So it's normally maybe a copy of passport or driving license, or and maybe a secondary um, uh, ID as well on top of that to satisfy yourselves that they are who they say they
yeah.
are.
Yeah, got you. So, and based on that question, if for as long as that ID isn't provided, you sit on that subject access request until such point in time when it comes in, or does it ever sort of is there like an expiry on a subject access request, or does it just sit until those
No,
criteria have been met?
yeah, I mean, if they don't come back, yeah, that's it. I mean,
Yeah.
as I said, the clock won't start ticking until
No.
they
Yeah.
do. But they don't have to refine their request, but
Okay.
organizations can ask them to. So you do have that right to ask them to clarify it.
Brilliant. Right. I cannot believe how fast we're going time wise. There's so much to go on. We've had so many questions. It's fantastic. So these are questions that actually people who'd registered for today's session sent through in advance just so that we would cover it, which is fantastic. And for future webinars, I'm more than happy for this to happen. If you've got a specific concern or question you'd like us to cover. So can we refuse a subject access request, Megan?
Yes, you can. If it's manifestly unfounded, I'm using wording from the
Yeah.
legislation. It's not how I normally speak. It is, if it's manifestly unfounded or excessive, you can refuse the request.
Yeah.
But making that judgment call is quite difficult because
Okay.
there's quite a lot of examples in terms of when that is relevant. So where someone is clearly making it a request to be difficult, and they actually say that they're doing that, which
Yeah.
they might not do that.
Yeah.
So
Does
there's a
this
lot
does
of
this
things to
happen?
think about.
Sorry, spoke over you. Does this happen in instances where someone is maliciously, repeatedly submitting requests as well?
Yeah, so that can happen, and so you potentially might go down that route for
Yeah.
those.
Okay.
Again, it's a high bar in terms of
Mm,
demonstrating that, and often it can be easier just to deal with the request, but that's entirely down to the organisation to make that decision.
got you. Okay. So the second one that came in was how do we determine or define, I guess is a word there, whether a request is complex?
So there's a number of factors that you would look at. There's some guidance on the ICO website that supports this as well, but you'd be looking at actually who is the individual in terms of, for example, is it an employee? How long have they worked with us? How much data do we possibly, or personal data do we potentially hold about that individual? What's going on? So the context of what's going on in the background. Are you potentially going to have to seek some legal advice if there's maybe an employment tribunal going on? So there's different factors that you would need to take into account. Is it complicated because it's years and years of social care records or health records? So you'd be looking at the context in terms of what level and amount of data you might need to be trawling through in terms of providing that response.
Got you. And can we charge a fee?
On a general principle, no, because as I said, they're free now, but you can, if, for example, you have responded to a subject access request and someone comes back and asks you for copies of that information again because they've lost them, you could charge then. Or you can charge down that manifestly unfounded excessive
Yeah.
route, potentially charge them there. So you could either refuse or charge them for the information. So you can, in some cases, is the answer to that question.
Okay. Brilliant. Now, any other questions? Again, more than happy for Megan and I to be sent questions by email. But there are on the Information Commissioner's website some FAQs on the landing page, and that link can be found through the logo. And as when you get the slides, you can go to that link, so you can find some of them there. We'll quickly whiz through the case study so we have a bit more time for questions. So first case study, which this is from the ICO's website in September 2022, where they announced action taken against 7 different organizations, completely unrelated organizations, who'd failed in their duty to respond to information access requests. MOD, Home Office, London boroughs of Croydon, Lambeth and Hackney, Kent Police and Virgin Media. And the comments and the statements within the reprimand documents on the ICO website, and this is not specific, these were varied across the 7 organizations. These are the kinds of things that the ICO had to say, and some quite astounding numbers, although I guess, Megan, that relates to the nature of the organizations we're talking about
Yeah.
here in terms of their scale and size. But the message that I got when reading this and then putting these slides together was that maybe they grossly underestimated the resources that were needed to deal with this stuff, or some of them were just so complex they just didn't logistically have the right things in place to manage them. Is that the right sort of view, or is there more to it than that?
And it's the nature of what those organizations do as
Yeah,
well.
yeah,
So in the context of policing and justice, that's always complicated. A lot of these backlogs also emanated from the COVID period as well. So where a
yeah,
lot of people workers weren't able to go into offices, so backlogs started to build up because to respond to subject access requests, you might need access to paper files and stuff like that. So
yeah,
that is where definitely work started backing up for a lot of these big organizations. But I've seen smaller organizations taking months and months and months to deal with subject access requests for no reason that they just don't have the resource to deal with it or the knowledge or expertise in house. So it does vary. Um, but some of these big ones get significant numbers of requests every month. Yeah.
yeah, yeah. Would it be ethical isn't the right word? Would it be the correct process that if they know from the outset they're unlikely to meet the timeframes, that they at least let the subject know that this is going to be happening? Or
Yes, and you should do that, and that then helps to avoid complaints going to the
yeah,
ICO. So even if you're going to miss that deadline, even by a few days, maybe a week or something, you might
mm,
say it's taking longer than expected to respond, but you will get a response by.
yeah,
And then, as I said, that avoids the ICO getting involved with it.
yeah. All about good comms.
Yeah.
Um, Not a million miles from where I'm sitting now, Plymouth City Council, May of last year, failed to provide access to personal data and copies. Again, very sort of similar theme. This was over a period of 3 years, with very specific stats in this instance in terms of their compliance rates, how quickly they were responding within the deadline, um, and how many within the 90-day period, etc. So yeah, very interesting to see. And I know from reading this kind of stuff, Plymouth City Council is not alone in terms of councils and regions and county councils, etc., across the country. Uh, their response rates generally are very common. Um, in this instance, 18 took up to 2 years to complete. Some hadn't even been completed after 2 years. So some really long time periods there. So this would suggest that this particular council was really struggling with their SAR process during
And
that
it's a
period.
difficult, it is a really difficult area, and
Mm,
staff turnover can be quite substantial
yeah,
in terms of if you're tasked with just dealing with subject access requests every day as your job. That is quite a big ask, and they're not the
yeah,
highest paid people in organisations either. So
no,
it is a really challenging role, particularly for these organisations like councils that get many requests.
yeah. I mean, for anyone on today's call, I think the one thing that I take away from the session today and from this subject is that if you invest some time and effort on polishing your process, it will pay dividends in terms of the overall cost. Because without doubt, when you look at the stats like we're looking at on the screen now, the one thing that really stands out is an obvious financial cost as well to the council, um, for having to deal with these and the length of time they're taking. Um, the most recent example is the Labour Party, and this was from on the ICO's website from August of this year. Megan has a bit more background on this one, which is interesting. So I'll ask Megan to comment in a moment about how and why this happened. Um, so this investigation hinges on or relates to a cyber attack from October 2021, Megan, doesn't it?
Yes.
So what actually happened?
Yeah, so I'm not across the detail of the actual cyber attack and the
No.
ins and outs of that, but there was publicity around it, which then generated a number of subject access requests coming in from people to check whether the Labour Party was processing their personal data.
Yeah.
So the Labour Party set up a specific privacy email inbox. I'm not sure what it exactly was called, but probably privacy at Labour Party or something like that. But no one was monitoring that. They didn't think to
Okay.
do that. So they've set up the inbox. No one's monitoring it. So all these requests are going into a dead end
Yeah.
inbox and just sitting there. And that all came to light as part of that, which is why they've had the reprimand.
Got you. Yeah. So in attempting to manage a situation, it created another um, very
Yeah.
significant situation. Yeah. So um, yeah. So really, and there's loads of other case studies out there. If you go to the ICO's website and you look at action we've taken, that will show you in chronological order with the latest at the top of the action they've taken, whether that's um, monetary penalties or whether it's just reprimands, cautions, etc. So, as promised, just a brief summary of what is going on as of yesterday, really, Megan, isn't it? In terms of we
Yeah.
don't know a great deal at the moment, but something's happening.
So there had been some legislation before the election, which I called the Dippity Doodah bill, which was the data protection and something bill, which dropped before the election. And that had some reforms around data protection in it.
Yeah,
What has happened now is we have the data use and access bill, and that was laid in the House of Lords yesterday. And that does have some amendments to the data protection legislation specific to the UK.
yeah,
I've had a quick skim. There's nothing hugely relevant for subject access requests apart from a potential to include something around searching for personal data. So reasonable and proportionate searches. So when you get that request, you're not potentially going to be required to look through everything from the point of creation to date, but you would be expected to carry out reasonable and proportionate searches. And that links back to what I first said initially, that a lot of complaints to the ICR are around people not believing the organization has provided them with everything they hold. And I think going forward, as long as that organization can show that it has done a reasonable and proportionate search, then that is possibly going to be deemed to be fine in terms of compliance. But as I said, it's
yeah,
only landed yesterday, so we don't know what's going to happen as it goes through the
yeah,
houses.
yeah. It's very fresh, and I think fair to say, as is the nature of more ClearComm and what we do and the areas we work in, we'll absolutely focus on this in the coming weeks and months, and then at a certain point in time where we feel it's appropriate, we'll run a webinar which focuses specifically on the bill, and make sure that everyone on today's session is aware of it, and of course
Mhm.
invited. So uh, yeah, so just a very brief, before we go to get some questions in, just a brief overview of one of our core services at More ClearComm, which relates specifically to today's webinar and all of the sessions we've run previously, because we feel, and the reason I'm mentioning it today is because I think it really does offer support in relation to subject access requests. It's our data privacy advisory service. We call it DPAS for short. It can support our clients in a variety of ways in relation to all things data privacy and data protection, which can all be knitted in also to our cybersecurity work as well. But this is what DPAS can offer, and it covers all of the sort of areas that I've listed on screen. Again, this will be included in the slides that you receive, and any questions you've got, you can email me at the email address at the bottom of the screen. We work with clients in a variety of ways. No two organizations are the same. They all need different levels of support and different types of support. So it's just basically worth a conversation with us to talk about the sort of things that concern you, and hopefully we can help you in the future. So in terms of questions, got 13 on screen at the moment we haven't addressed. So let's work from the most recent back and see how we get on. Okay, first one, if the ID provided by the requester is out of date, such as an out-of-date membership card of a trade body, would we be able to request a valid ID to progress the SAR? I guess
Again,
the
it will
answer is yes.
depend.
Yeah.
Yeah, I think so. I mean, it depends on the context. But yeah, you need to satisfy yourselves that you're content that that individual is who they say they is, and they should be able to provide you with up-to-date ID to prove that.
Yeah. Next one, something we definitely deal with. We have clients in health and social care. It's a big point of focus for us as a sector for a variety of reasons. So we support social care clients with DPAS services, data protection officer services, DSPT, which won't mean anything to anybody who doesn't work in care, but it's very important. The question here is, working for a social care organization, some people we support, their information gets requested by family members. I always ask for court deputyship, lasting power of attorney. If the family member doesn't have either, can we refuse to release the information? When you've answered this, Megan, I've got another kind of observation on this, which might be worth adding.
Yes, you need to make sure that the person requesting the information about someone else is authorized to do so. And
Yeah.
like you've said, the standing power or lasting power of attorney would be satisfactory in those circumstances. So yes, and otherwise you'd be refusing it entirely. Yep.
Yeah. So the point I was going to add to this is that there are social care providers, whether it's care homes, domiciliary care, etc., as with other organizations in different sectors, rely on third-party software to carry out day-to-day tasks. And some of the software used by care providers will allow for the sharing of client data, patient data with family members. That doesn't necessarily mean that's something that is legally okay, Megan. I think it's fair to say it's just a feature they've built into the software. The responsibility sits with you as a social care provider as whether you permit and allow that kind of access, because it isn't necessarily something that's compliant in data privacy legislation. It's just, don't assume because it's a feature in some software that it's okay to use, I think is worth saying.
Yeah, and I mean, it'd be down to consent of the patient if they have capacity to, or the individual at the centre of this, the patient, whether they have capacity to consent to their family having access to those records as well. That's not having access, or that ongoing access is not generally deemed to be a subject access request. That's sort of a
No.
one-off request in stone, if that makes sense, or point
Yeah.
in time.
Yeah.
Ongoing access is a completely different kettle of fish, and you'd need to look at that from
Yeah.
many different angles.
Could it be considered a breach if something's shared with a family member that the client didn't give permission for? Or?
Yes, possibly,
Yeah.
because unauthorized disclosure is
Yeah.
one of the breaches. Yeah,
Got you.
absolutely.
Okay, so we're not too bad at the moment still, a couple of minutes. How do we manage repeated DSARs? We have one individual who makes a request, all information sent, and then the following year he sends another.
So, what in those cases, be you wouldn't necessarily need to provide the same information again, but if there was anything substantial between that person's last request and the current request that you might need to disclose, you would only need to disclose that, the interim information, if that makes sense. Yeah.
That's good to know. Yeah, that's
But
very
if it's
important.
repeated in terms of falling into that category of manifestly unfounded, excessive, repeated requests potentially come into that. So you might want to look at it through that prism as well.
Got you. Okay, next question. If we have to provide every email sent, is there any protection against vexatious SARs?
I'm not sure what that means. You wouldn't
Yeah.
necessarily have to produce every email sent. Again, it'll be
Mm.
down to the context. So yeah, it's very much down to narrowing that down. Um, what was the second element of that question, Rich? Sorry.
Is there any protection against vexatious subject access requests?
Yes, there is. There's the manifestly unfounded that aligns to
Yeah.
vexatious, sort of, and that gives you that ability to, um, can I say, get out of jail free
Yeah.
on that
Yeah.
one. But that's very much a complicated assessment in terms of whether that applies or not.
Got you. I just want to thank everyone who submitted questions because I had a feeling this would happen because it is a very personal type of subject, and you will all, most of you will have had experiences of this and maybe have some concerns and worries. We won't be able to answer any more questions live, but I will be making sure that every single question is answered in some feedback notes. And if you have any questions beyond that, please send them to us in the next day or so because we'll then include those as well. They'll be all anonymous. It's more about making sure that everyone can see the questions that were asked,
Yeah.
so that everyone on the session can actually benefit from it without obviously naming who's asked the question. So of course that'll be protected. So just finally, our next webinar, this is actually the last one for 2024. So the next one is going to be in January. We'll be reviewing the kind of cyber threats that the team has experienced and we've seen across the industry in 2024 and maybe what to expect in 2025. Likely, I think they will be focusing some attention on AI and the impact of AI on cybercrime. This affects everyone on today's session as much as subject access requests do. So I definitely invite everyone to attend. All of our cybersecurity webinars are delivered in plain English. We don't use jargon. We understand that it's a subject that's very much as much or more about people than it is technology. So, and that's definitely the theme that we adopt. So that's Thursday, 23rd of January, again from 10 a.m. That'll be managed by members of the more ClearComm cybersecurity team and myself. Um, thank you. Possibly the fastest session it feels like, Megan, that we've had
Yeah,
since
it does.
other we ran a session back in August of 2023, which was focused on the initial 5 years of the GDPR and how that had looked. And again, that was absolutely packed with questions, very relevant to the audience. So this feels a bit like that. That hour has flown by. So thank you as always, Megan. Fantastic insights. Questions still coming in. I promise we'll answer them all. But for now, many thanks. And I'll see you on a future webinar, Megan. Enjoy the
Yep.
rest of your
Thanks,
day,
Rich.
everyone. No worries. Take
Okay.
care.
Thank
Bye bye.
you. Bye.